did to us at the session. I'm sorry I wasn't here earlier, so I need to get a feel of who is here. So, how many are on your planning commissions in your counties? Okay. How many are employees of the county? What are your roles, Johnny? What do you do? Okay. Are most of you planners that are the employees of the counties? Okay. Anybody here from Salt Lake County? Nobody from Salt Lake. Okay. What about Davis, Utah? The reason why I bring those up is because, as I was going through this, I was thinking more of the rural counties. And believe it or not, Scott, in Washington County, we still consider ourselves a rural county, but when you drive around there now, it doesn't feel so rural anymore. But most of the changes, I would say, that happened to CLUDMA have to do with those counties that have more population in their unincorporated areas. A lot of the laws and changes carve out those counties that have less than 5,000 in your unincorporated areas, or they have other provisions for those of you that don't. But what's unique about the rural counties, as you know, is a lot of you act as a municipality too, because you have people living in these unincorporated areas that are kind of like towns, but not necessarily have been incorporated. I'm just going to go through some of the highlights, and Meg, I'm glad you're here because you can help chime in on these. There are so many bills that kind of touch on land use, and I admit that I took this from a few presentations that have been done by the League of Citizen Towns by Rachel Otto, who is fantastic, and Meg, you may have had a hand in putting some of this together too. And I tried to carve out some of those things that really had to do with cities, and just those things that apply to counties and some apply to cities as well. Some Meg probably has touched on, so I won't do as much talking about those, and it sounds like John's going to do some of these this afternoon too. But just to give you an idea, this year there were almost 1,500 bills that were considered. When just 10 years ago, 5 years ago, 1,000 bills would have been unheard of. That is the way it's multiplying up there. Everybody's got an idea, everybody's got a bill. What does that do? That makes it difficult for Johnny and his staff, for UAC, for the League of Cities and Towns to track all of these. And so sometimes some things slip past us, and we don't realize it until after we're going everything through all the legislation that's been signed, that something is going to affect us in a way that maybe we hadn't considered. I don't know if any of you saw this Tribune editorial. It was a pretty good one. They were almost right on. Basically, what they said was, hey, legislature, butt out of those local issues that we think are best handled locally. Now, one of the things they did say was, but we think it's a good idea for the state to do the affordable housing. I don't know if I necessarily agree. I mean, how many of you think that you can make the housing more affordable in your counties? That you, as a county, as a planner, is there anyone here that thinks you can make it more affordable? How many of you think you're charging exorbitant impact fees or plan processing fees? I'm just wondering. No one, right? And yet, that's what they're saying is, basically they're turning to us as locals and saying, you should figure out a way to lower the cost of land. I don't know how to do that in Washington County especially. It's going up like crazy. There's nothing we can do. You have to do something to control construction costs. And you, by the way, are the reason why they cost so much because of all the fees that you're charging. Now, how many of you think that any builder in your counties, if their fees were lowered by $10,000, I'm not saying you charge that, but let's say you did, how many of you think they would lower the cost of their home by $10,000? Okay. All right, so you see the position that we're in as we go up there and try to talk to a developer-oriented legislature on how to protect ourselves with those fees that are necessary to pay for the planners and to pay for the infrastructure that you're putting in. But it was a good editorial nonetheless. Here are some of the overarching themes that we had. Obviously, housing and housing affordability. Luckily, we had the the Medicare problem, and we had the marijuana problem, and that kind of side, and the tax bill was kind of, you know, heaven sent to us in a way that it just kept everybody consumed and probably kept it from doing more damage than they did on some of these issues. So we're hoping for another one. So if anybody wants to legalize anything, get on it right now. Let's get them distracted again. Referendums. How many of you have heard about the case in Holiday? You know, all the planners should be aware of that. That was, I think that mostly highlights maybe some of the things that Meg touched on. And one of those is, judges do not understand land use. I mean, we're here trying to explain to you all how this works. We're not even sure how it works in some cases. I get calls all the time, Meg does too, on just interpretations from county attorneys and city attorneys saying, how do you interpret this code? Because it's not as clear as we think it is, or we have conflicting ordinance with what our policy says, those types of things. And so this referendum, this particular referendum was, I think, kicked down the road by the Supreme Court on purpose. They didn't render their quick decision until after the vote, because I think they were too chicken to be honest, because it was something new to them. But here's the interesting thing, and Meg, you'd agree with this, right? Usually when we get together as with the Property Rights Coalition, they are saying your planners are rogue, your planning commissions are rogue, your cities are rogue, you know, you've got to do something about that. But in this case, they're going, hey, the city was right, we got to support cities. Don't you agree? We got to support planning commissions and city councils and county councils and commissions that make these decisions. All of a sudden, they were on our side on this. It was an interesting case. But when Meg was talking about the distinction between legislative and administrative, that's more important now than ever. So look at your codes. We've been redoing our zoning ordinance in St. George for a year and a half. That's how long it's taken us to do it. We're so busy and trying to get everything done. But we're trying to push everything we can to the administrative level. Meg touched on this, where a lot of times the elected officials want to retain control, and you've got to educate them on why they don't want to, because it could expose them to a referendum. And we don't want that. So try to push everything you can to that administrative role. Trust your staff to do the right thing. You guys are mostly staff, so you're looking out for the community as well. So you got to get them to trust their staff. Land use, we had the gravel pits, although it's called critical materials now because gravel pits doesn't sound good. Nobody wants a gravel pit next door, but we're all concerned about critical materials, right? So we'll talk a little bit about that later, but there's a task force that's going on right now. Water was a big issue this year. We think we've got most of it handled. It's all dependent on approval of a change in our constitution to allow for extraterritorial water service more easily for places like Salt Lake City, but also for a place like St. George, where we own the water treatment facility, but we kind of handed it over to the Conservancy District to treat all the water for the cities around us, but we can't technically give it to them because the Constitution prohibits us from doing that. We want to fix things like that. Beer, kind of a weird thing to put there, but now with the changes to the liquor laws, you guys control the sale of beer. And you can decide if you want to do the background checks, you can decide where, if you still don't want to. Does anybody ban beer sales on Sundays or on election day still, or things like that? Really? Really? Oh gosh, some people make better decisions when they're drunk. So you might want to reconsider that one. But yeah, most places have kind of done away with those. Really what you need to decide now is, what do you want? Do you want a background check still for those people, for those that are selling beer? And what do you want, the proximity requirements and things like that? Those are up to you now. That was made probably a year ago. Tax reform, why does that affect us? Well, if they had proposed some of the changes in how they were going to redistribute the sales tax, a lot of our cities, maybe some of the counties, but they zone, they used to call it zoning for dollars, but they do zone with the eye of getting some sales tax revenue because we're so sales tax dependent, right? So if they were to reconfigure that formula, maybe in St. George, we don't want to take all the traffic and all the headaches we do with all that and say, hey, that's great. If we're not going to get the sales tax from this, or they're going to cap it at a certain point, let them go out and build it in Leeds or wherever it may be, and we don't have to deal with that. So it could affect your zoning, but also truth in taxation. They would probably want to do a property tax hearing, and we all get drawn in to that because we might have to raise those. And then, of course, generally local government authority. And Sonia, you're going to let me, or John, you'll let me know when I have like 10 minutes left?
Yeah.
Okay. Okay, so just real quick. There was a change in the law on legal notices. There used to be, we used to have that newspaper publishing requirement. We've always tried to get rid of those, but the newspaper lobby was powerful at one point. Now nobody reads newspapers anymore, and so the legislature is getting more and more convinced that we don't necessarily have to do that. So you still, with the changes, still have to post on the public meeting, the public notice website. So anytime you're required for a public meeting to put out notice, you have to put it on the public notice website. You guys are all doing that right now anyway, right? So it's just no change on that. But in the counties from the 3rd to the 6th class, which I imagine most of you are, you still have to do the publication. But if you're going to do, it allows for a personal service instead of publication in some cases, but if you do, you have to, the person that is serving them, that's required to provide the notice, has to clearly identify the parties. I'm not sure what that means. Proof, they have to keep proof that all the parties have been identified, and then they have to retain that record of service for 2 years. I think that's a lot of hassle. I think maybe right now I would just go ahead and continue to notice like you have in the past. But there is that option there. Truth in taxation amendments. Just the only reason why I bring this up is because it says now that if your county is going to have a truth in taxation hearing, they cannot have another public hearing on that same day unless it's for a budget or enterprise fund. So what does that mean for you? If you're in a fast-growing county like Washington, or for a city like St. George, we'll have 18 plats or 18 public hearings on an agenda sometimes. 10 public hearings. And so if you are going to do a truth in taxation, you either do it on another date or all those developers have to be put off until your next meeting date. Because some of you, how many of you still have the public hearing at the commission level or council level rather than at your planning commission? Do any of you still do that? Remember, only required to have one public hearing? Okay. I know that there are some, or a lot of cities, including ours, where we're changing it now, but there are a lot of places where they'll have a public hearing at the planning commission level and at the county commission level or the city council level. If you're going to do that, you couldn't have that truth in taxation hearing on the same night. They want to be able, rather than have people yell at you for the bad zoning decisions they make in the same meeting, they just want them to yell at you for raising their taxes. So I thank the legislature for thinking of us on that. Remote notarization, just a heads up that the Lieutenant Governor's Office is going to be promulgating rules to do this, and a lot of our documents need to be notarized. And this is kind of a 21st century thing. So as they come out by November with their procedures for doing that, one, you may want to consider getting the notaries in your offices or counties to also get approved for the electronic verification. And you want to be aware of the rules in case someone else wants to electronically verify and notarize a document that you're required to notarize. Okay, so on the initiatives and referenda, I will tell you that I am not the expert on the changes on this. However, I will say this, we saw in this last case with Holiday that the timing was off for being able to protest, the city or county being able to respond and get it all done in a timely manner before the actual ballot, before it actually went on the ballot. And of course that was emphasized by the fact that the Supreme Court, with their expedited hearing, still didn't issue an opinion until well after the election and that ballot issue. So, but here's one thing that's interesting. And I think we're going to see more and more of these um, these referendum or initiatives driven by zoning, because people are becoming aware of their ability to do this, and that's a legislative act. But in the past, our hands have been really tied on what we can do as a governmental entity to get our side of the story out. This law changes that, and it empowers our elected officials to explain why they voted or approved that particular project or took that legislative action. And so that part will be very helpful. Land use law is what that is referred to in this initiative of referendum change is a law of general applicability enacted based on the weighing of broad competing policy considerations that relates to the use of land, including land use regulation, a general plan, a land use development code, an annexation ordinance, or a comprehensive zoning ordinance or resolution. That's pretty broad, right? That's a lot. Think about those times, especially when if you're a county that's starting to grow fast. And if you're also like anybody from Grand County or Garfield, any of those places, you know, where we're just getting inundated with tourists from all over the world going to our parks and recreational areas. And so there's a push for a lot more development out in the county. In fact, I work part-time as the Apple Valley Town Attorney, and we just had a large developer come in and say, I've got all this land, you know what I'm going to do? I don't want to be subject to you guys. So I'm just going to go to Washington County and develop a big subdivision out in the county, which I know the county.
And I want it to be annexed into the city.
That's right. That is the right attitude you should all take. If there is a town close by or a city, annex it. Have them annexed. And you know what the great thing is they build their hotel, and he still gets the 4.25%, 4.25 TRT, and you know, the county still gets their share of the sales tax. So why not put it in the town or city and not have to deal with that, servicing that area? But so I just kind of chuckled when they said that and thought, oh, great, go ahead. I want to see what the county's going to do. So I'm not worried. But anyway, very broad. It's kind of scary that all of these, can you imagine if everybody got to vote on every land use decision in those categories? What would happen? I mean, it'd be chaos. Timelines, I just want to point out that a legislative action that is not land use, the timeline for gathering the signatures is April 15th, before the election. And if it's a land use legislative action, August 30th. So there's some different timelines there. They're just saying that some of your smaller areas have different thresholds of what they need to meet. The county clerk will help you on that. A lot of times, you know what the county clerk will say? They'll turn back to you and want you to interpret that for them. So you just need to be prepared for that if one comes up. And also, they put in there that we can't limit the public meetings unreasonably. So sometimes, you know, you'll have someone say, that's in charge of the meeting, the commissioner that's in charge saying, you each have 2 minutes, and if you're saying the same thing, I don't want to hear it. Well, if you're going to give everybody 2 minutes or 3 minutes, you give everybody 3 minutes, even if they repeat everything. Just also some changes. We are allowed to do a proposition information pamphlet where we get to put our side of the issue in there, and that those that are out there expounding for the other side and collecting signatures have to distribute that with our side in there too. And then, but otherwise we can't use emails or any of our equipment to advocate for it, but we can answer questions basically if people call. Okay, Meg, did you go over changes in 315?
Not really, no.
Okay, so I'm just going to 315, how many of you have read that bill, the changes to Lebanon? I recommend you all pull it and you read those changes. They were meant to help streamline the process. I will tell you that working on this bill, by the end of the session I called it the Frankenstein bill, because everybody started making changes even though we gave them opportunities before the session. During the session we had so many changes that it really got to a point where I wasn't sure what the bill said anymore, and you had to keep rereading it. We know this, we're probably going to tinker with it a little bit. But what it did, is change some of the definitions, change some of the language on the land use authority, how we do plats, the vacation and dedication of streets, judicial review of land use decisions, what a judge can do. in those cases because we don't want the judge to actually sit as if they're the land use authority. We want them to make their decision and remand it back for action after that, but not really decide that land use issue there in the court. They'll say whether they think we follow the law or not. They can revert back. Boundary line agreements and referendums. Okay, so we addressed the administrative process for subdivision and boundary line agreements, trying to make it easier so people can come in and just administratively get these things done. I will tell you one of the frustrations and one of the things changes I'd like to make is there was pushback on some of these boundary line agreements on the recorders getting the municipality's signature or the land use authority signature on these boundary line adjustments. And we think that's critical that that's done because we see a lot of times, especially when the downturn came, where a home was foreclosed on and the mortgage was on the platted lot, but they had done a boundary line agreement with their neighbor that gave them 10 more feet in the back and recorded it, and we had no knowledge of that, which is illegal, but the recorders still accept those. And now we had a no man's land of 10 feet because they could only foreclose on what the platted lot legal description was. And the other party no longer owned that parcel. And we see these things happen all the time. So we're trying to clean that up so that there's some, at least recognition administratively, that we've checked them as towns and cities and they meet the ordinances. And you as counties will want to do that too.
So, in addition to my commission stuff, I'm a realtor.
Okay.
We have a 5-acre property where this owner sold four of the 5 acres. You need 5 to develop it without septic tank. That's an illegal lot. Will this fix that?
Well, I will say that right now you have the ability under the law to make them put those lots back together or they can't build on it. Okay, you still have that. What this was meant to do was to say that can no longer happen because once that person went in to the recorder's office and said, I want to do this boundary line adjustment, the recorder's going to look at it and say, wait a minute, which county are you from?
Wasatch.
Okay, Wasatch County has their land use authority has not signed off on this. So you need to go. What we're trying to avoid is making him go back to the commission to get that done. Or you're still a commission, right? Maybe not, right? Okay, so, but that you have to go to the land use authority, whether that's administratively, that's what we're trying to do, is say, just go to your planner, and have them certify that it meets the code. Because also we'll have people that will put the lot line 1 foot from their house. And nobody has a 1 foot setback for most of their single family homes. And so that causes the problem too. So what we're trying to do is prevent that from happening again.
But on stuff that has happened,
You can still legally make them put it back or say you can't use it. You can't use that property. Here's the problem is, and I have this quite often, you'll have the new owners in your office in tears saying, we bought this and it's our dream home, and now you, city attorney, because the planners didn't want to sit down with them, are keeping me from building my dream home, you know? But you can legally make them put that back or they won't be able to build. They won't be able to get the septic approval. So,
thank you.
Does Washington County's recorder do that? Have you
None of
convinced
them do,
any
yeah,
county
right.
recorder to do that?
no.
You have to have a
And
magic wand?
that's why we're trying to put it in the law. And we got pretty far, but not quite.
One of the things that we're trying to, not all the cities in Washington County are doing it, but the county and the county planning department and county recorders, one of the things that we've started doing now is, it's as simple as we had a stamp made that says approved and signed on it. So when it comes in for the administrative review, we don't want in the future, when I get fired for doing something stupid and they hire someone else, that planner knows that lot line adjustment or that boundary line adjustment was done. There's a stamp on it. And so the recorder's office is looking for that with the county stuff now.
So I will say this, that those of you who are planners here are probably frustrated by that too. So we need your help this session to make sure, at the very end, our compromise was, okay, they can go down and record it, but within 5 days, or we had a time limit of recording, you have to notify us, notify the jurisdiction where that occurred, in writing with a copy of the recorded document, so at least we could try to unravel that after the fact, which is more difficult to do than before. So if I have the support of the planners in the counties to say recorders, you gotta do this because it's causing a lot of problems. That would be great, because we'd like to make that change this year.
The recorder is the one that gives that information? Or the,
Well, but the recorders did not want to have to notify us at all. And so we said, okay, look, how about if we do this? How about if we put in the law that after you record this boundary line agreement, that you have to, within so many days, send us in writing a notification with a copy of what was recorded, so that we could look at it after the fact and say, that doesn't work, and we could contact them and at least, try to fix it.
The problem is the money is already transferred.
Oh yeah, no, listen, it causes all kinds of problems when people do things illegally. I agree. So, but sometimes we have to say, that's not the only
Buyer
way.
beware.
Yes, that's what you have to do. You have to say it's not we don't have the recourse. We do, so.
And I just wanted to bring it to you from the recorder side. The statute tells the recorder, you must record anything that somebody comes into your office and asks you to record.
Yeah.
They don't get to approve or review it to determine whether or not they should record it. They have to record it.
And-
So from their standpoint, it isn't that they're saying, we don't want to tell you that this person is asking to record this and that we're going to wait for your stamp. They can't.
Yeah, well, and so, let me respond to that. Because they kept saying, we don't want to approve it, that's your job. And we're saying, that's right, it is our job. So we don't want you to approve anything either. All we want you to do is, like with every plat you get that has to be signed off by the Land Use Authority, that on these, you just have us sign off on it. You don't have to approve anything. You just get it, you just look at, like you do with the plats and say, signature not there, go back and get the signature of the Land Use Authority. So we're not asking them to approve anything. Neither is Box Elder County. When they go in, when he's not asking the county clerk or recorder, to approve the zoning or the lot itself. All he's saying is, have them come to me like they do with the plats, and we'll sign off on it, and then you know that it's good. You're good, whether it's legal or not. You don't have to worry, because we're the ones that made the mistake. If we made a mistake.
So without that signature, and it's not recorded, the funds can't transfer.
Well, right now, under the current language, you can still do it administratively, and they can still record that if they follow the language that's in the code. If you read that statute, it'll say exactly how you do that. And we're hoping this year to make it so that, with some other corrections we need to make to 315, that it'll also say that the recorder, that the local land use authority has to sign off. Now, people fear that because they say, we want to make this process simple. Well, this process would be simple, because rather than going through and having go through a planning commission or anything, you just go straight to the Box Elder planner and say, here it is, we followed everything for a boundary line adjustment. He looks at it, says, yes, it meets our zoning, it's got the minimum number of acres, there's no setback problems, anything else, signs off on it, it's all administrative and works. It'll still be a very quick process. That's our goal. So there were lots of other things, but I think how much time do I have left, Johnny?
We've got plenty of time.
Okay.
Can I ask one more question? on
Yes, absolutely.
So, unless I'm looking at the wrong section of state code, I was always under the impression under boundary line agreement, it basically says a boundary line agreement is not subject to the review of the land use authority. So, and I know a lot of counties and cities have requirements that say, even applications, you have to file an application with the planning department to get an administrative approval of that. Does the county and city have the authority to
Delegate this to the court.
basically override this section of state code, or can the resident can push back and say, look, it says right here,
Yeah.
you don't have the
No, I
authority.
think the resident could push back under the code and say, we're following everything that we need to do. And we're still okay with that process. Meg talked earlier about updating your ordinances. How many of you have ordinances that are completely up to date and have the changes from the last 2 sessions in there? Just curious. Because, sometimes I feel bad as city attorney when I look at ours, and here I am involved in all this stuff, and I look at our ordinance going, oh my gosh, we gotta find time to update these. But then I look at Salt Lake City's and go, oh man, I'm doing good. So it's tough to do, and that's one of the things we get beat up on. But I would say that there are a lot that aren't following that. But I have no fear of someone following this process. As long as it administratively comes back to someone on your planning staff that looks at it to make sure that that unsuspecting buyer that the commissioner from Wasatch County was referring to doesn't get stuck with a 4-acre unusable piece of property. That's what we're trying to do, is we're trying to prevent that. It's harder to unravel that. In fact, I just had that discussion with one of our large title companies in St. George that was upset that we were requiring someone who had done an illegal subdivision of their property in the back, and he's saying, well, it's still owned by the same owners, what do you care? They want to build a building on it. So because it could legally be, you could mortgage that property, you could sell it to a third party. How are they going to have access? Doesn't have enough parking. And he says, well, that's easy for you guys to do. Once someone comes in, just deny them the building permit or go back and force the landowners to put it back together. And I said, well, wouldn't it be easier just to correct it at the beginning, which is what we're asking you to do before you build your building or anything? Give us at least an easement, cross-access agreement across the neighboring property so it can get to the public roadway, so it can have enough parking. That's all we're asking. But his position was, no, he wants the sale to go through. Let's just let him do this. And then you guys can fix it later when they come in for a building permit. Almost impossible to do, right? That's what we're trying to prevent. So I agree with you, a lot of doing it in the wrong way. Okay, so let's see. Some of the more important things, we simplified the processes for vacating public streets. It got to be a little cumbersome, especially when all you're doing is realigning a roadway that was along a river, and now you're pulling it over, maybe because someone wants to develop along there. So the roadway will remain open, it's just being realigned, and you have to abandon that and go through the process and vacate it. We just wanted to make that process easier. Public easements, this is one that we're still having some discussion on right now. And before, there's a protected public utility easement. That is when Questar, or whatever they're called now, Dominion, one of those, they have their utility easement in their own name, they own it, they're the ones that have a right to be in there. Then there were the utility easements, public utility easements, and then there were municipal utility easements. And everyone was using these interchangeably, the public utility easements and the municipal utility easements. It hadn't really been a problem until now. We used to have a problem in St. George, we have our own power company, with everybody wanting to attach to our poles. We're mostly going underground, and the majority of our city is underground right now. Now it's trenches, and I don't know if you're seeing this now, but there are fiber companies coming out of the woodwork, and everybody wants to put a conduit in your trench. Some of them are putting them in there, and you don't even know it. We found a whole cable operating system down in Sun River that we had no idea had been installed there, and they were in our public utility easements. Well, their argument was, it's a public utility easement, we have a right to be there. And we say, they're ours. We control what goes in there. Well, there was that question, well, do you own a public utility easement, or should we be calling them municipal utility easements? We changed it to municipal utility easement, and there's been some discussion of maybe clarifying that a little bit more. What we were trying to clarify is you as counties can control what goes in those easements. Because there comes a point where you have too many, and when you go to do road work or have to realign something, you'll have conduit in there with fiber with a company that you didn't even know was there and no longer exists, so we don't know what to do, who to notify. In fact, in one of our situations in St. George, when we took down our underground on a very busy roadway for a long stretch, We had one line left on the poles, one single strand, and we're criticizing the paper for everything for probably 7 months. And it was only because we didn't know whose fiber it was. So at one point we said, we're just gonna cut it. And then right around that time, we discovered that it was the hospital's fiber line for sending all their medical information from one campus to the other. So if we had cut it, you know, that could have caused a problem for someone in the middle of surgery, but, you know, those are the kinds of things you have to worry about now. So that's why those easements are important. Just kind of take a look at those. We tried to clarify that all the plat requirements need to be met before the reporter can record those. The certificate of occupancy, that one is an interesting one because we are very limited on when we can deny a CO now. And I would say this, if you have any large developments that go on in your county, if you have a large resort complex or something that comes in, even a hotel, I would almost do a development agreement with them now because certain things under the statute are, what's the terminology now? I forgot, Meg, that we use.
Public and private.
Yes, the public improvements are defined as, I don't know, some essential life safety things. And so the question is a carport an essential public improvement that needs to be done on that? What about a clubhouse or a pool? Let's say they came in and said, we're going to do this nice hotel and it's going to have this great pool and everything. You guys are going to love the landscaping and everything else. Is that something you can withhold the CO if they get down to the time when the building's done, but they haven't done any of these? And there's a question on that. And there are different ways to get around it, but we've decided, a lot of us, that maybe you just do a development agreement for all of those, have a form development agreement, and you just fill out all of those requirements that they have to get done before you give them CO. In fact, one of the major attorneys that was pushing this has a large developer in St. George that put up a large apartment complex and none of their carports, and wants the CO for their last building now. And we're saying no, because luckily it was approved before the law change. But we're saying no, you have to put those up before we'll let you move in the building. But now, I don't know what we're going to do. So you can require a bond or another public assurance to get those done. Public Infrastructure District Act. How many of you heard about this? This is actually a new law that allows for property owners to form what is essentially a SAA, or what we call SID, for a project, and bond for the public infrastructure in that. You get to define as counties what you consider public infrastructure on that. Although there's a definition in the code, it might include sewer and water, and you may say, we just want this to be a sewer project. We don't want a huge bonding debt on this. So that's what you're going to be limited to. But it has no recourse against you. It's 100% of the landowners have to agree, and the recourse is through the property owners, through the tax collections, and there are specific ways that is to be noticed on your tax notice and collected. The good thing is, it's 100% of the property owners have to do it, so it's usually a developer or developers that are doing the project together, and you get to set the design standards for that public improvement, the roadways, the lighting, the infrastructure, and it's turned over to you right away, and it's free and clear of any type of lien, indebtedness, or anything like that as far as you're concerned. So it might be a way when you have a large developer coming in, like we do in the town of Apple Valley, where we don't have the funds to do this, but we want to make sure that they get all the infrastructure in at the beginning. This would be a perfect way for them to be able to do that, and then if they go under, we don't have to worry about the unfinished infrastructure. Just some of you, or most of you, should be aware of this development advertising amendment having to do with illuminated signs and outdoor advertising, that you have to give notice to those owners of parcels with a 500-foot radius. It says if it's a unified commercial development or planned development. Well, we all have different terms for planned developments, and but the definition of unified commercial development is in the statute. You have to notify them, those landowners adjacent, and you have to begin construction within 1 year of the actual project of putting up that sign. Gravel pits, there's probably some more that, I was involved in some of the negotiations, but, you know, we need someone like a Draper City to come and some of the other rural counties that have dealt with the gravel pit issues to really talk to you about the problems that come with those. But the legislature felt the need to get involved in this. The bill that that came out at the end, Meg, would you agree, is much better than what they had proposed, but we're working on it in the interim. But you know that if they were legal non-conforming or permitted before, as of January 1st, 2019, they get to continue. And there's really nothing you can do on that. And also, there's no expansion by right, but they are vested. Let me see what's on the next one. Let's go back. Well, look at the, okay, this definition here is critical. It's extraction, excavation, processing, or reprocessing of critical infrastructure materials. We've already had that issue come up now because there was a parcel of property that they were doing the crushing of the rock, and now they want to mine it. And they're saying, hey, under this statute, we were already processing or reprocessing on this property. So we want to now we have property next door that we've got to mine on. We want to continue on this. So the question is, and Meg, what do you think? Do they have the right to do it? Do they have the right to mine now because they were actually processing or reprocessing the material? It's a tough one. I'm leaning towards they have the right to do it. I'll let John weigh in when
Well, if it's ambiguous, who does it go to?
See, there we go. So now with the tie, and I just don't want to be I don't want to be the test case or the example at the next session, right? I prefer that someone else do that for me.
And this is temporary, right? We're working on updating this now, and so this was effective just for a year? Is
Yeah.
that right, that bill?
Yeah.
So
Hopefully we'll get something that we can all agree on. And maybe get some clarification on that issue too. But this is an issue for counties that comes up quite a bit. So water bills, I think I'll skip that one just in the interest of time. Meg touched on affordable housing. I would just say this, you know, it only applies to first, second, and third class counties. So most of you are probably out of this. But like Meg said, it could be headed your way. You know, you're in a Grand County, for example. Look how expensive it is to just buy a used home there. You know, just an existing home right now. I mean, some of these areas, even though they're small, the price is going up because we have a lot of people coming in our state buying real estate around our recreational areas. Tax reform. I only bring this up because will counties be forced to raise property taxes if they come up with a distribution formula that doesn't work very well? And how will any changes to that affect your zoning strategy, like I said earlier? So now, do you want to encourage commercial development if you're not getting much of that sales tax revenue? Transient room taxes, only touching on this because some of you may provide these EMS services and you're in a county with a national park and you may qualify, or you already are a resort community. You can actually get now, those resort communities can get some of that TRT. But I imagine that as a county, and I didn't check this, but I imagine as a county, if you're doing that you should be able to qualify too. And certainly if Brad Last didn't put that in the bill, it should be something that should be in there. Because a lot, like Washington County, we have $20 million in TRT, and yet there's services that have to be provided for all these people. We're limited on what we can do with it. You probably have, some of you have that same problem. Okay, so just know that there are several programs on rural economic developments, and the reason why I brought that up is because in my experience back in the day when I was with UAC, a lot of the planners also wore a hat of economic development. Do some of you, are you in charge of that at all? Maybe not so much anymore. And so whoever is, just know that there are some programs out there that will help you to develop some job potentials. And then the CRAs or the old RDAs, just know that there were some changes made. That always affects the county, but more at the commission level or the council level on agreements and diverting taxes, the tax increment, and and there were several changes there. Now, how many of you read the Medical Cannabis Act? Have any of you read that? Okay, so Johnny has, so he actually has quite an interest in cannabis, apparently. And that's because you came from Arizona or something? I mean, oh, there you go. See? I'm from California, so I read it too. And, but there are some pitfalls here that I think you need to be careful of. It says that the county must allow production in at least one industrial zone if you have any industrial zoning. How many of you have industrial zoning? Now, I actually had an attorney tell me the other day, advised me, well, St. George only has manufacturing zones. So you don't have to worry about this and you don't have to allow it. How many of you think that's a good idea if I were to say as city attorney, we're just going to do it that way? And how many think that at the next session, we'd be used as the example of why cities are obstructing things, or counties? I say, look, if you call yours a manufacturing zone, that's your industrial zone, just treat it that way. Don't tread on this because I think you'll have problems. County also must allow the production of at least one agricultural zone if you have any. How many of you have agricultural zones? There you go. So
are you required to do, so obviously I think we have both, but can you take which area and force them into one of the two, or do they get to pick?
they get to do in either one. So if you have an ag and an industrial, you have to, and if you have multiple ag zones like A1, A2, whatever, you can pick that way. If you have different industrial zones, you can pick which industrial zone you think it fits best in, but you have to do it in those two zones. Do you agree? I mean, have all of you, Meg, do you agree? Anybody have?
Yep,
Yeah. So,
as far as we know.
It's gotta be
We're
involved.
just getting used to it.
okay, so, you cannot deny or revoke a cannabis production permit solely based on a violation of federal law regarding the legal status of cannabis. I also think it's interesting that this bill says that it's legal when federal law says it isn't. I don't understand it, but all I know is you'll have some people in your community that will say, they'll push back and say federal law does not allow this. But under state law, you have to violate federal law.
How does that work?
How does that work? I know, it's just an interesting way to put it, but again, I think we'll let someone else be the test case on this. But other states, you know, I think the feds are in a position now where it's going to be very difficult for them to push back because so many states have approved some form of production.
Just a thought, I think most ordinances, county ordinances, city ordinances, somewhere say, we can disapprove if there's a problem with federal law. So does that need to change in their ordinances? Like it's set for?
Except for, yes,
Okay,
it does.
That's interesting.
Now, here's what I would say is, I probably wouldn't change my ordinance on that aspect, but I certainly would put in when your table that Meg suggested, it has your, those uses that are permitted, I would list these as permitted uses in the zones that you pick. I think that's the easiest way to do it. And then just leave it like that and just kind of let it go, right? Because there's so many other things that would violate federal law you don't want to.
Do we have to designate it as permitted, or can we assign it as conditional?
Well, tell me why you would do it as conditional.
Just to be able to regulate the development so it meets certain standards
The standards
that
are
are
set.
already set.
Yes, and the state is the one that approves that. So, now it does say that there are some local ordinances, and you have to defer to local ordinances. I'm not sure, as I read that, whether that meant, like for the pharmacy that we'll get to, whether that meant hours of operation or something like that. If you're going to do a conditional use, which I think you could, I personally advocate trying to do away with as many conditional uses as you can, because they get us in trouble all the time. Make sure you follow the criteria set out in state law for evaluating it, so you don't run afoul of that. So you could do that too. If you want to see what that's going to look like, at least be aware, have that heads up. Yeah, so you can still do that. You can not deny a business license for the same reason. So just be aware of that.
So there's a good resource, which is Andrew Rigby at the State Department of Agriculture, and he came to our conference in the mid-year session, and he has lots of information and details on this if you guys haven't already chatted with him about implementation and enactment.
And believe me, he's had a lot of chatting at our, is anybody from Grand County here? Okay, so even if they were here, I'd say this, but it was funny because after he did his presentation, the Grand County contingent went up and said, why aren't we going to get one of the pharmacies? And you're going to put one in St. George. They can drive down to Mesquite. We need one over here in Moab. And so I think there are going to be places I think there's going to be more pharmacies than the state initially planned on. And I think we'll have more production facilities too. There's been a lot of interest. In fact, on my way up here, I got a call from someone that's interested in doing one in St. George. Okay, so pharmacies, let's talk about that. They're not dispensaries, they're pharmacies. And they'll have special pharmacists because, technically a licensed pharmacist in the state of Utah, if they were to dispense cannabis, would be violating federal law and could lose their license. So they created a special category for this, a pharmacist. And you cannot deny or revoke if based on a violation of federal law, the location or having pharmacy in the community. It's a permitted use in all zones in the county except, well, there's an answer to the question on pharmacy. 600 feet of a zone that is primarily residential, 600, and I don't know what primarily residential means, but I have a feeling that this was intended for those projects like we have in some of our cities where you have maybe commercial on the bottom floor, but 4 floors of residential. 600 feet from a community location's property boundary, that's a church, a public or private school, a playground. The playground's interesting because they specifically say playground in there. Well, that's going to exclude your parks, but I don't remember if it said park in there or not. So most of your parks have a playground. But anyway, you can look at the definition of a community location. So 600 feet from a community location following the shortest route of ordinary pedestrian travel. So if they don't ordinarily cross the highway there, then you can make them go down to the corner and come back, which we've had to do for some of our liquor licenses. And then 200 feet from the patron entrance of a community location's property boundary. So you're not talking about the doorway, you're talking about their actual property boundary.
Sean, isn't that kind of like the Chili's in Layton where they put the, it was right across the street from a school, but in the parking lot of Target, and they ended up, so they could get the walking distance, they send the people through a maze like you're at Disneyland to get to the front door.
Yeah, and it could be like maybe a large city in Washington County where they had a restaurant right across the street from the park, and so we said, oh, you got to walk down to the roundabout, across, back over this way, back behind the building, and come through the back door, which is now their front door, and we made it by a foot. And then my public works department, after they got their license, like within 3 months, put a crosswalk right across the street there. And so I was like, oh, you just eliminated all the rest of this development from having serving alcohol. So, here they are worried about pedestrians. I'm worried about getting our liquor permits. Okay, so what's coming up this year? For sure, we're going to have some modifications to 315, and hopefully we can clarify some of this having to do with the recorder's duties and how those are occurred. We want to work with the recorders on this because we want it to be seamless and easy, but we want everybody, we don't want the unsuspecting buyer to get stuck with a lot that doesn't work, it's not conforming. As Meg said, we're going through the critical infrastructure material statute, and we should have something this session that will be in place forevermore. But just know those gravel, more than likely, all those gravel pits that are in operation right now are going to remain in operation if they are legally existing or non-conforming in January of this year. And we're going to have additional affordable housing requirements, and that's where I think the counties may get, the smaller counties may get roped into this too. So just be aware of that. And definitely, there's going to be more bills on limiting your ability to do the planning and zoning. And let me tell you, how many people in your counties know what's going on at the legislature and go up to the sessions during the session? How many come to you when you have a zoning issue or a gravel pit issue? or all of those. They pack your chambers. You know, the local, we're where the rubber hits the road. And so I think UAC has done a very good job of protecting your rights. This league is doing a very good job of protecting our rights, but it's a constant battle every year, and we always need your help and your support. And if you ever see a bill that you think has problems, and like I said, with 1,700 bills, you can't catch all of it, call UAC. Call Johnny. He'll start the ball rolling. Call the league. Do whatever you need to do as a planner, as a county commissioner, whatever, to bring this to the forefront, because we don't catch everything. And we need your input because you know what goes on day to day better than we do. Are there any questions? Oh, yes.
I had heard that the critical infrastructure materials bill got passed with some unintended language in it that restricted local communities from changing their regulations with regard to gravel pits. Is that?
I don't think it was not unintended. I can tell you that much. It was, and we did have some cities that were very opposed
Well, it
to
was
it.
supposedly going to not be included in the bill, but then the final approved.
Did something slip past us on that? Because I know Crane and I were reviewing that over and over again when they came back with their changes. Do you remember, Meg?
No, there's one sentence in there that will be removed, and it was about that this didn't relate to, that this bill didn't, I forget the exact sentence, but it didn't, this wasn't subject to your land use codes or something to that effect. It was very a weird anomaly, but it's going to come out. So, but beyond that, no. I mean, obviously it limits your ability to do anything about the ones that are vested. But I think the negotiation right now will be what that future limitation looks like, right?
Right.
So yeah, nothing that I have seen going through. There was that one thing that said that this was somehow outside of all your land use regulations, but I think that was an anomaly.
So
And
nothing big to worry about.
Nothing big, but did we require some plat language for any, I believe, any plat that's coming in within 1,000 feet of an operation has to have specific language on that plat?
Noticing, yes.
And that is in the
And
code.
it's incumbent on the operator, though, is my understanding.
And I just think, we would be better off anytime a plat comes in within 1,000 feet to make sure that language is there. Just because you want the buyer to know, it's not the gravel pit operator they call and complain to, it's us. And we've had that happen in St. George many times, whereas our developments encroach on existing pits. But we also have a new large development that's going in right now, and they want to mine as they're going. And so luckily we had put in, just because we didn't want the phone calls, 1,000-foot radius around any of their temporary mining activities that they could not plat. And once they did plat within 1,000 feet, they had to stop the mining activity. And lo and behold, this law came along, and we were like, boy, we're glad we did this. Because you'll have some operations that say we want to take down this hill over here, and we want to put it over and fill this wash over here. And we want to keep platting as we're doing this. And all the calls when they blast come to us, all the noise complaints and dust complaints come to us too. So, any other questions? All right. Thank you, Sean. Thank you.
And this is the case with, I'd say 80%